we find ourselves in the court of first instance in Brussels, Belgium. On the 17th of June 2021, an important verdict was delivered relating to a case of climate change litigation. The court states that the government breaks its duty of care by failing to take necessary measures to prevent the harmful effects of climate change. It follows no contractual liability of public authorities pursuant to Article 1382 of the Belgian Civil Code. It also follows the violation of the rights of respect for private and family life, referred to with Articles 2 and 8 of the European Convention of Human Rights. Due to the lack of good climate governance, and for repeated warnings from the European Union, the Belgian public authorities were fully aware of the certain risk of dangerous climate change for the country's population. In particular, they didn't act with prudence and diligence within the meaning of the aforementioned article of the Belgian Civil Code. The court, in fact, states the liability of competent authorities as the three criteria for establishing it, negligence, damage, and the causal link between the two, are met in this case. According to the judge of first instance, the defendants have not behaved with due care and diligence, and continue not to do so as for the serious and very likely threat of dangerous global warming, three of which they are well aware and that could be avoided by effective preventive measures. Moreover, defendants have not at present taken all necessary policies to prevent the effects of climate change on private and family life. They are protected by Articles 2 and 8 of the European Convention on Human Rights. This discipline, in fact, applies to threats to the environment at a level of severity constituting a danger for the lives of individuals and likely to harm private and family life of individuals, also in the absence of a quantifiable damage, as the present case. Let's go deeper into the case. The parties of the litigation are Klimaatzaak, a non-profit organization of concerned citizens, and 58,000 citizens. They dispute the responsibility of the Belgian State as well as of three regions, Walloon region, Flemish region, and Brussels Capital region, for not adopting necessary environmental policies due to the climate emergency. According to the court, the claim is admissible because plaintiffs have a personal interest in the action pursuant to Article 17 of the Judicial Code. The Klimaatzaak has a direct personal interest in part as an environmental organization. It can sue to defend the environment from harm because, in accordance with its corporate purpose, is specifically aimed at fighting against climate change and not at defending the general interest without further specification. The citizen complainants also have a direct personal interest because they seek to hold Belgian authorities responsible for the climate consequences on their daily lives. The fact that other Belgian citizens may also suffer damages does not transform their interest into a general one. Moreover, pursuant to Article 18, Paragraph 2 of the Judicial Code, action can be brought to prevent the violation of a seriously threatened right, as the case under consideration. To better understand the case, it is necessary to analyze the main conclusion of claimants. They argue that competent authorities have failed to act on climate policy. In particular, the defendants, Belgian State, Brussels Capital Region, Flemish and Walloon regions, have neglected their duty to exercise due caution and diligence. In developing their climate policy, they have not behaved as public authorities should do. Following the Intergovernmental Panel on Climate Change, the increasingly high concentration of greenhouse gases in the atmosphere, in particular those of carbon dioxide, causes global warming towards 4 degrees in 2100 and subsequent lifetime damages. In fact, scientific studies demonstrate that above 1.5 degrees, all dangers will increase substantially, affecting aspects of daily life, including those of Belgian citizens. In this sense, there are several measures issued at international, European and national level to prevent dangerous anthropocentric global warming. Just consider the 2015 Paris Agreement or the European Regulation on the Governance of the Energy Union and Climate Action. Looking at the national level, climate governance is an extremely shared competence, taking into account the division of powers in the country's federal setup. According to a widely shared consensus, there is the need to reform the institutional framework that is low-performing. This solution could contribute to enhance a more intense cooperation between the states and the devolved levels. For these reasons, plaintiffs ask for the assessment of no contractual liability of public authorities in accordance with Article 1482 and 1483 of the Civil Code. In addition, they argue the violation of claimants' right to life and their right to private and family life, pursuant to Articles 2 and 8 of the European Convention on Human Rights. They also claim the breach of children's rights in accordance with Articles 6 and 24 of the United Nations Convention on the Rights of the Child. In fact, young children and adolescents will bear the consequences of dangerous warming. They will experience the transition from 1 Celsius degree warming to 4 Celsius degree warming in the coming years, something that has never happened before in the history of the planet. Plaintiffs call for the court injunction directing the government to reduce greenhouse gas emissions on Belgian territory. Specifically, the request is to order the defendants to take the necessary measures to reduce the net emission of at least 42 to 48% in 2025 and at least 55 to 65% in 2030, compared to 1990 levels. It also provides for a penalty payment of €1 million for every month of delay in enforcing the judgment. The court declined to issue the requested injunction because of the separation of powers doctrine. According to it, neither European nor international law directly requires Belgium to reduce its greenhouse gas emissions by the various targets set up by the plaintiff in their application. In fact, neither the government declaration nor the various plans or other strategic documents are in themselves a source of legally binding obligations for the Belgian public authorities. The specific targets, therefore, were a matter for the legislative and executive bodies to decide. If the judiciary is competent to establish the default committed by the public authority, even the exercise of its discretionary power, it cannot assess the appropriateness of its action. In fact, the plaintiff's conclusion relies on the report of expert group on climate and sustainable development. The latter, while scientifically meritorious, does not constitute a legally binding source of obligation for public authorities. It is merely an expert opinion that can assist the public authorities in implementing their climate policy. In other words, the way in which Belgium will participate global greenhouse gas emission reduction target is currently a matter for its legislative and executive bodies, that is the result of the political arbitration. Relating to the practical developments of this revolutionary case law, the verdict is not followed by environmental measures by competent authorities, but further climate deaths and, in accordance with scientific prediction, an increase of suffering will happen. For these reasons, climate case proceeds to appeal. It is primarily aimed at the tribunal's refusal to set specific binding targets related to the reduction of greenhouse emissions over time. According to the appellants, the Brussels Court of First Instance has computed two distinct sources of liability. It limited itself to taking as a reference only the emission reduction targets laid down by rules of positive international European and Belgian law, and refrained from analyzing the authorities' conduct in the light of their knowledge of danger and of what needed to be done to help prevent or limit it. At present, the appeal judgment is pending. It will be interesting to know the outcome of the trial, especially in relation to the possibility of or not from the judge to oblige public authorities to adopt specific environmental measures. To find out this, it is therefore necessary to follow the judicial evidence.